We have both parties as well as their respective attorneys. We are here on the plaintiff's motion for a temporary order. Mr. McConnell.
Thank you, Your Honor. I believe that Mr. Lemon and his client renoticed their motion to set aside the default that has been entered against the defendant.
They did.
So,
I'm sorry I didn't mention that, but yes, that is before me today.
so I would think if the court agrees and Mr. Lemon has no objection, I would think that the default would be the first thing we hand him because if you don't set it aside, then that's going to be, yeah.
You're absolutely correct, Mr. Lemon.
Okay, thank you, Your Honor. Yeah, I appreciate that. So right, there was a default entered in this case on October the 10th, and the motion to set aside the default was filed 4 days after my client received it on October. So she received the notice on October the 10th, and then she retained counsel the next business day, which was the following Monday, and she then filed the motion to set aside the day after that. So that's where we're at sort of procedurally. Under the court rule, the motion to set aside a default, can be granted upon a showing of good cause. And while the rule doesn't define good cause, the Court of Appeals has said that trial courts can look to the totality of the circumstances, and there's a non-exhaustive list of factors that the court is supposed to consider. But it includes factors like how promptly the defaulted party acted, whether there's prejudice, the size of the judgment, whether the default would result in ongoing liability. And, while we acknowledge that, I'm sorry, Your Honor, while we acknowledge that my client, missed the deadline to answer the complaint, and it was just due to a misunderstanding of what it was she was signing when she signed the acknowledgement of service. And, that may or may not by itself constitute good cause, but I think that there's sort of a number of factors here that compel setting aside the default. So number one, Ms. Adams acted immediately upon learning of the error. Number two, there's no prejudice to the plaintiff, at least not any that he's been able to articulate. And number three, I think that the magnitude of the issues at stake here demands resolution of this case on the merits. So, and I want to focus for a moment on that last point, Your Honor. So, number one, this case involves custody of the party's minor children. Per the motion for a temporary order, you can see that it is clear that the plaintiff believes that this is not a simple default case where the court can kind of divide things easily and without hearing from the parties. We need to have a parenting time schedule. We need to have child support. My client has been a non-working spouse for, she's been a homemaker for the last 7 years, since 2018. So, this case also decides her financial future. The purpose of a default is to, it's a punitive measure, and it's intended to enforce compliance with the court rules. And, well, I understand that, and we acknowledge that my client missed the deadline to file. I don't think that it is just to decide her financial future, sever her relationship with her children, and essentially, if the plaintiff's motion is granted, render her homeless without at least hearing from her first. I don't think that is coextensive with the omission that she made.
All right, thank you, Mr. McConnell. You did file a lengthy response, so you don't have to go through the whole thing, just hit the highlights.
Yeah, well, I appreciate it, Your Honor. I just think that MCR 3.2102D allows default to stand and even allows the defendant to continue to participate in the case, but if the court gives the court the ability to exercise discretion and put some limitations on what she can do and what she can't do, the court has to independently make a finding about the best interest of the kids and so forth in terms of custody and parenting time. It has to follow the manual for child support. So it wouldn't be like she's prejudiced there. For the reasons I outlined in our brief, we don't think there's excusable neglect here. She didn't understand. I don't think there's any case law out there that says that's excusable neglect. So we would ask that the court deny that motion, default stand. To the extent the court is going to grant the motion to set aside, we refer the court to MCR 2.603 D4. I'm sorry, so the previous court was 32010C2C or 2D for the discretion part for the default to stay. 2603 D4 allows this court to set a condition of paying cost attorney fees to my office before the default set aside. I have $1,455 in fees related only to the default. In responding to it and handling it today, we would request the court to order the defendant to pay that to my office before the default set aside.
Great, thank you. The court finds under the court rule that there is good cause to set aside the default, relying heavily on the fact that this the motion to set aside the default was filed very shortly after the default was actually entered, and also from a practical perspective from the court's view, which is if the court fails to or denies the request to set aside the default, the court has to set a damages hearing where, frankly, the defendant would have very limited participation, and the court really needs to hear from both sides if we have a really fairly hotly contested custody parenting time and the other issues in this case. But I will follow MCR 2.603 D4 and require that the attorney's fees that Mr. McConnell just mentioned be paid before the default is actually set aside, and request that he forward a list of an accounting of those fees to Mr. Lemon so that he can ensure that those fees are appropriate.
Thank you, Your Honor.
All right, thank you.
Would the court like me to go into my motion or Mr.?
Yes, please go ahead.
All right, thank you, Your Honor. The court, I'm sure, has reviewed the motion. A lot of my argument here is not going to regurgitate what the court's already reviewed, but I do have the plaintiff has some responses to the response filed by the defendant. First of all, the issue of exclusive use. We were perplexed when the defendant, under a verified response, argues that she's staying overnight at the marital home several nights a week. My client has been keeping a calendar. She's not staying at the marital home on any regular basis. She's staying with what, upon information, belief is her boyfriend, a gentleman named Mr. Ed Ross, who lives near downtown Rockford. That's where she's primarily staying overnight, and frankly, she's even taking the kids over there to stay the night at certain points. But according to my client's calendar, she had 7 overnights in May, 5 overnights in June, 0 in July, 5 in August, 5 in September, and 3 so far in October. So for the last 6 months, she spent 25 total overnights at the marital home. He essentially already has exclusive use. But given what I'm going to go into here, it's important that we separate these parties for some of the facts that we've alleged, the evidence we provided the court. She does sometimes, and maybe on a more regular basis, come over in the mornings. This will be the argument you'll hear from the defendant to help the kids get off to school, which is really not necessary. We have a 16-year-old and 11-year-old. The 16-year-old is going to be driving within the next few weeks, which I'll get to in a minute, because she's going to finally take her Session 2 driver's training, which after she completes that, presumably she will, she's a smart young lady, she'll immediately get her license. They'll go down to Secretary of State, get a license, and now she'll be driving the two of them to school every morning, bringing them home, presumably. The mornings aren't necessary. They're not, but we don't think that she's doing much anyway because these kids are very, very self-sufficient. So that's not really a good basis to deny the request for exclusive use. She won't be homeless. She's been staying with her boyfriend. I'm sure he will let her stay there. She's been staying there recently, so they still have a relationship. She has her parents who have, we understand, space, and are good grandparents. I live up in Cedar Springs, which is not too far. And we said that, look, if she's going to stay at if the parenting time is going to have at the grandparents' house, where it should, not the boyfriend's, that my client will make sure that there's transportation until Sophia can drive. He'll do all the transportation to and back, to there and back to make sure the kids are safe because the defendant can't drive because of her suspended license. We have the allegation of abuse here. The response was that was not caused by the defendant. We stand by our sworn testimony. What we left out were some facts that we thought were too inflammatory. But when this happened, Ari left. It happened at the boyfriend's house. Ari then had the fight with mom, leaves, runs away from the boyfriend's house where mom's staying, calls my client, the plaintiff, who has to come pick her up in the evening hours of when this occurred. She was obviously upset. So he had to go find her in the streets of Rockford, pick her up, bring her back to the house. That's what happened. And we'd be interested to see under oath how the defendant gives you that story. The response references, why have we called CPS? Why have we called the police if these things are so, egregious? Well, we don't want CPS involved. We don't have to. We don't want the police involved if we don't have to. Nobody wants the kids to be subject to that kind of interaction with those agencies. It's just not healthy for them. And so my client has just simply tried to avoid it. The response references this mysterious criminal matter on page 4 last year. I asked my client about that, and apparently what he tells me is that the defendant was drinking and driving and was tailed by the police, somehow got home by evading the police, came inside, locked the doors, and then started, wouldn't let the police in. And that led, her attorney can describe what happened, but that led to some kind of criminal proceedings. And that was just last year. You have the videos, Exhibit 1 and 2, of the knives and the suicidal threats. We're glad she's getting counseling now. Hopefully she sticks with it. We don't want anything bad to happen to her or anything unhealthy, but it's still a cause for concern that gives us the basis to make sure we split these parties up and we keep the home safe for the girls. And then last night, Your Honor, the defendant was out drinking and she came home and she caused a scene and she called the police and the police came over. The police interviewed Mr. Adams. The police interviewed Miss Adams outside. Mr. Adams was allowed by the police to stay in the marital home, stay in the home with the kids. The police then took Miss Adams away. We don't know where. I don't know. We don't know if they took her back to her boyfriend's house to drop her off there. We don't know if she spent the night in jail, but this happened last night. This is not a healthy environment for this defendant to be there causing these problems around these kids. These kids should not have to see a Kent County sheriff's officer in the house interviewing dad for no good reason. It has to stop. So that's why we're requesting exclusive use. If the court grants exclusive use, the parenting time that the plaintiff has proposed is very reasonable, we think, at Grandma and Grandpa's house. It's on page 6. I won't go through it. It's every other weekend, some time on Wednesday, so she doesn't go a long time without seeing the kids, alternating holidays, 2 weeks. We do have the restriction on any alcohol or drug or non-prescription drugs for the defendant, during or 12 hours before. But we think it's a very reasonable parenting time proposal at Grandma's and Grandpa's. So if the court grants exclusive use, we request that. We're also requesting sole custody temporarily until we can get the defendant to give us a good track record where she's getting counseling, getting help, and getting, her addiction or substance abuse issues under control. And then we can later in this case revisit legal custody. We just don't think she's of the right mind right now to be able to make important decisions affecting the minor child. Child support, it's attached as exhibit, I believe it's exhibit 5 or 6. 6, where we did the calculations. We imputed $40,000 to her. My client makes 50. So we think that's a reasonable imputation given the wages these days. So for all those things, we request, Your Honor, that the court grant the relief that I just went through. If the court will allow me a couple of supplemental requests for relief, since she doesn't have a license and Sophia's going to have a license soon, we would like that car, which is titled in my client's name, returned to the care and custody of my client so Sophia can use it. She has a job now at an elderly home by the Meyer on 10 Mile. She goes 4 days a week and she has a double shift on Sunday. And right now my client's taking her. But if Sophia has that car that the defendant shouldn't be driving anyway, then that makes everything much easier for Sophia and for my client and for the entire family. We would also request that the restraining order, I think counsel was agreeable with the restraining order and harassment. We'd also request, unless Mr. Lemon objects, to making that a mutual restraining order as to finances too, except for ordinary expenses. So I'll let Mr. Lemon weigh in on that because we have some concerns about some gambling that's been coming out of the joint accounts by the defendant. So, Your Honor, I know I was a little long-winded, but a lot of facts, a lot of relief requested in this hearing, and so I think I've stated it all. And if the court has any questions, I'd be happy to answer them. But we request that relief. Thank you, Your Honor.
Thank you, Mr. Lemon.
Thank you, Your Honor. So I think, it's important to say when I first got this case and, my client came to me, I thought that this case was going to be very easy. And my very first email to Mr. McConnell said, hey, if you want to talk about resolving this one, I really think that, it sounds like the parties are on the same page. Everything's good, and that was my client's genuine belief at that time, based on what the plaintiff was telling her, was that, we were just going to have joint custody. We were going to have 50-50 parenting time. The financial stuff was going to be split evenly. They had a plan for that. So much so that in our response, in our answer, my client didn't even ask for alimony, even though she's been a stay-at-home mom for 7 years, because that wasn't part of what she understood the parties' agreement to be. Then I filed my appearance in the case, and we filed a motion to set aside the default. And now things have gone downhill very quickly. My understanding, I'm sort of surprised to hear Mr. McConnell say that we need a financial status quo order. That was going to be one of my requests to the court today, because my understanding is that the plaintiff has essentially cut my client off financially. He is now depositing all of his paychecks. Remember, he's the sole breadwinner by his own admission. He's now depositing all of his paychecks into a different account that doesn't have her name on it. He has changed the passwords to the parties' financial accounts, including the mortgage, the car loan, the home equity loan, so that she doesn't have access anymore. And he's also started, as part of this campaign, to try and alienate the kids from her, telling them that she's crazy and that they shouldn't talk to her because anything that they tell her, she's going to use in the divorce. So I think that this motion for the temporary order is, really just more of the same. The plaintiff went through the text message and the videos of his phone and found every incident from the past 7 years where the defendant was ever angry or depressed or said an unkind word to anybody, and filed a motion trying to get the court to kick her out of her house. A lot of the alleged incidents didn't happen at all, or if they did, they happened very differently from how plaintiff claims that they happened. And so I think that if the court is even going to entertain this motion, we're going to need to set an evidentiary hearing for it, because we have substantial disputes, as Mr. McConnell himself points out, substantial disputes of material fact, about, how much is my client sleeping in the home anyway? Did this alleged abuse of Ariana actually happen? Right. But I will note that if we do set it for an evidentiary hearing, that's, I think, also part of the strategy here, because, my client's a stay-at-home mom, has been for 7 years. She, and the plaintiff knows she can't afford a knockdown, drag-out legal battle. And so, I think I strongly believe, my client strongly believes, that the plaintiff's parents are paying his attorney's fees. And so if we're going to go to an evidentiary hearing on this, we respectfully ask that the plaintiff be required to pay my client's legal fees as part of that. So everything else in the motion depends on the motion for exclusive use, because if there's no exclusive use, then there's no reason to have a parenting time schedule. There's no reason to decide custody on a temporary basis. There's no reason to enter a child support order. So let me start there. We have in the file and the allegations, right? There's no testimony that the plaintiff is scared to stay in his house. There's no threats against him. There's no threats against the kids. There's no real violence that's been, alleged. There's not even a safety concern that the plaintiff himself took seriously enough to ever report to anybody until now, right? As we say in our response, he sort of vaguely refers to alcohol problems and erratic behavior, which all of this, history happened years and years ago and just isn't a concern anymore. She's a stay-at-home mom. She, as Mr. McConnell said, she comes to the house every morning, even when she's not staying there, and gets the kids ready for school, and gets them off the bus when they get home. I understand that the oldest is sort of on the cusp of adulthood, but the youngest is 11. So the idea that they don't need their mom strikes me as a little crazy. And I would add that, my client has no independent income, and the solution of, oh, well, she can just go stay with her boyfriend. The parties are polyamorous, by the way, Your Honor. So that's the I alluded to that a little bit in my response, but both of them have had extramarital partners by agreement. So, I would hope that the court would not look askance on that, which was an intentional lifestyle choice that the parties both made together. I understand that may be distasteful, but it has nothing to do with whether my client ought to be able to, be in her home or not. But anyway, the court cannot order third parties to take my client in. So what the plaintiff is really asking for is, we would like you to please order that the defendant be forced to live off of charity while the plaintiff enjoy full access to the marital home, full access to his entire income, and oh, by the way, please order my non-working spouse to pay me $700 a month in child support.
All right, I'm going to stop you because I am convinced, given the factual disputes, that we do have to set an evidentiary hearing. It's not something I like to do on a temporary order because we end up trying the case twice, essentially. But I will set this for an evidentiary hearing, and we will contact both of you to clear a date as soon as possible. And because this is a temporary order, I will set a date that we have to stick to, whether it really suits your schedules or not, but try your best to make it work. And I will order that the plaintiff pay the attorney's fees for the evidentiary hearing for both parties. And that's something that the court can address in the final settlement or judgment if it needs to be reallocated at that time. All right, we're adjourned. It did sound like the parties are in agreement regarding the status quo order. And
I think so.
that's status quo as of the time that the complaint was filed.
Understood. Thank you, Your Honor. I appreciate it.
And
So
then-
Your Honor, there's no exclusive use until the evidentiary hearing?
Correct.
Okay, thank you, Your Honor.
All right. Thank you.